everyone, it's Maureen Mahood again with Sell Your Home Charlotte here in beautiful Charlotte, North Carolina. And we are going to talk today with Joshua Lipack about the 2T offer to purchase for the state of North Carolina. It's the contract that we use when we help buyers buy homes. So Josh, we're going to go over page 1, which is going to be like due diligence and earnest money. And then tell us a little bit about like you and like, and then we'll dive into our fun times.
Sure, yeah, and thanks for having me back. As you mentioned, my name is Josh Lipack, and I'm an attorney with Grabowski Law, located here in South Park, Charlotte. We handle both residential and commercial real estate transactions in North and South Carolina, and we also handle estate planning, probate, and any sort of business law, LLC formation, things like that you might need. But today we're going to be talking specifically about residential real estate, as you mentioned, and going over page 1 of the offer to purchase contract, which I think you have a copy of with you right now.
Yes, we have. I'm going to share my screen so that we can pull up the contract so everyone can see it. And here. Okay, can you see that, Josh?
Yep, I can see it.
Okay, perfect. So this is page 1, the standard 2T offer to purchase. And let's, as a legal perspective, why don't you go over what all this stuff means?
Sure. And a lot of this is going to seem self-explanatory, but there are things worth noting, like even the beginning section here. Obviously, you're identifying the parties, the buyer and the seller, but it's important here to make sure that you use your full and correct legal name. Also, if you're buying property with your spouse, you want to make sure to include their name. And if you intend to buy it in a trust or in an LLC, that you put that name instead of your individual name so that that doesn't have to be corrected down the line. Not much else there for the moment, but you had mentioned earlier, you had ran into an issue with the middle section there where you identify the property. And oftentimes I see parts of this left blank where we only get the street address and not, for example, the parcel ID or the subdivision or the lot number. And even though the majority of the time the street address is going to be just fine in identifying the property, it's best practice not to rely on that solely. Like, for example, I bought a new construction home and the seller had the address wrong for mine because it was a new address and they put the wrong number down. So according to the contract, I was buying a non-existent property. So that's why, in my perspective, it's important to fully identify it as best you can.
Perfect. So let's go down to, and your agent will fill all this stuff out. So I know when I was trained as a new agent, don't leave anything blank on the contract. And if it's NA, then you put NA. So make sure people don't fill it in later. But let's go down to due diligence and earnest money, because this is where we sometimes have some issues, I guess. I don't know what, if you would call it.
Yeah, and this is I would say this is the most complex part of page 1 that we're going to get into. Purchase price, that's pretty straightforward. But due diligence and earnest money, this is a part that not everyone maybe fully understands or understands the ramifications of or the obligations there. So when you're buying a property and you agree to a certain amount of due diligence and earnest money, best practice is to deliver those funds immediately once the contract is signed. For the earnest money, it does specify within 5 days. Due diligence, it simply says that it's due effective upon the execution of the contract. That's not really clearly defined, though we would go with a reasonable standard, typically no more than a few days, I would say. But there's obviously extenuating circumstances. If it's the holidays, if it's a long weekend, if banks are closed, that's all understandable. But what's reasonable is that you make it a priority to get those funds tendered as quickly as possible once you're under contract.
And then, so what happens at that point? And let's say like I recently had I'm on the seller side of a deal and we went under contract on a Wednesday and it was the next Monday and we still hadn't had due diligence yet. I have a form that I can do to demand money. But like in reality, what is the seller, what kind of remedy do they have at that point?
As you mentioned, demanding payment is one option, although technically in that scenario, the buyer has breached the contract. Anytime, because we hear that terminology all the time, breach of contract, but basically what that means is anytime you have an obligation under the contract that you fail, to meet, you are in breach of contract. So if you are obligated to pay this money within 5 days or within a reasonable amount of time, and you don't do so, you are in breach of contract. The seller could treat it that way. They could demand payment to cure that breach and keep things moving. They could also simply consider the contract breached and unilaterally terminate if they wanted to and take another offer.
Okay. And then, so what happens at that point? Does the buyer still owe the due diligence fee?
If the time has passed, so yeah, if enough time has passed that they have breached contract, the seller could, like I mentioned, go with another offer, but also still demand payment as due to them under the former breached contract.
Okay. So the moral of the
You don't want
story
to end up in that situation. Yeah.
Yeah. Don't get in that situation. You go under contract, you either wire your money, you get a check, or you go to the bank. And so, like, I've had instances where, like, nobody has checks anymore, and wiring to a private person is kind of a little thing that a lot of people don't like to do because you've got to give bank information. So money orders and certified checks, we'd have to wait until Monday when the bank opens up. So that's not going to put us in breach if we say that.
Correct. And I'd also like to add that if it's a finance transaction, if you're working with a traditional lender, you're probably not going to want to do things like Zelle or other kind of Cash App transfers for the due diligence, because the lender might not be able to source that, or they'll have an issue with it in underwriting.
Gotcha. So Zelle is not the best way to go.
Unless they give you okay.
Yeah. I guess if we just move down to page 2, just real quick, we could just the due diligence period. So that doesn't matter if it's due diligence period doesn't start when I get you the due diligence money, right?
So the due diligence period starts effective when the contract is executed, or when the contract is effective, and it goes through whatever time period you insert here. And even though it's called the due diligence period, really this is more critical for the earnest money. And this is an important distinction between those two. Due diligence money, by and large, buyers should consider that non-refundable. There's only a few scenarios in which that could be considered refundable, like if the seller breaches contract and fails to disclose a material fact, or they fail to close within the set time for settlement, or maybe they didn't actually have clear title to the house and didn't have the ability to transfer clear title. These are all scenarios where you could get due diligence and earnest money back, but except for those rare scenarios in which the sellers fully breached the contract, yeah, due diligence should be considered non-refundable, but earnest money during the due diligence period is refundable. So a buyer can back out during that due diligence period for any or no reason and get their earnest money back. After the due diligence period, it becomes more difficult to get your earnest money back. And that's the importance of that period. It's your time to fully investigate the property, make sure that there's no defects that would, ultimately change your mind, so that you could at least walk away with your earnest money during that time.
Perfect. And then, so let's say a buyer decides that they no longer want the property during due diligence, and you do a unilateral termination with release of earnest money, or what do you do for that?
You would send a termination for both parties to sign, but at that point, the earnest money would be returned, like deliverable back to the buyer.
Okay. And so the seller still just has to sign it and release it then?
Yeah, they really have no way of strong-arming strict performance at that point.
Gotcha. Okay. Let's go ahead and come back to our screen with us. Okay. So what else do you want to say about due diligence and earnest money? Anything?
No, I just think it's important that when buyers are doing this, that they understand what that money's for and what scenarios they might or might not get it back, because it's a lot of money usually. So it's important to know what you're risking when you put that money down. Or when you say it's a lot of money, it's just like it's all negotiable. Sure. Yeah, but I mean, typically, and it fluctuates based on purchase price, but still, it's usually enough money based on the purchase price that it's going to be significant to the person buying the property. Correct. A lot of times if people lose their due diligence money, they have to wait a little bit more time before they can go back
to make another offer on another house. That's why we have to be super careful up front before we do an offer that this is, the one that you want, because we don't want to put you out of the home buying game.
And it's important to know that as soon as you sign that contract, you're obligating yourself to pay that money before you actually pay it. So it's important to remember that as well.
So the other thing is that a lot of people ask me too, okay, so the due diligence is a fee to the seller. What happens when I close?
The amount due to the seller at closing is reduced by the amount they've already received.
Yeah,
And
so they don't lose it. Yeah, so they don't lose it. It's if they close, it's part of their down payment, I guess you could say.
Correct. You're credited. So if you had, let's say, $5,000 due diligence to the sellers, when it comes time to close, whatever amount was due at closing would be reduced by $5,000 because they've already received that money from you. Yeah.
And sellers understand that money is going to come out of their proceeds. So it's like a debit on their side, due diligence, because they've already cashed the check.
It would show as a debit
Yeah.
that they're receiving $5,000 less than they would have had they not already received that. Yeah.
Okay. So moral of the story is pay your due diligence and your earnest money when you have a plan. Agents should have a plan with their buyers, and also sellers agents should also have a plan on how they want to receive it, because a lot of my sellers don't want wire transfers because they don't want to give their money. So checks or money orders, and how it's going to happen so that nobody gets upset, because the worst thing to do in a transaction is just start off on a bad note, right? So, all right. Well, I think this was great, useful information. Thank you so much, Josh. And we'll work our way through this contract. I think it's really important for people to understand what they're signing. And I think a lot of agents, including myself, understand the contract, but it's also really good to have another perspective, especially a legal one, of somebody who does this every day. All right. Again, it's Maureen Mahood, Sell Your Home Charlotte, here in beautiful Charlotte, North Carolina. And don't forget to like and subscribe if you like this information. And Josh, you want to sign off for yourself?
Yeah, no, thanks again for having me, and look forward to the next one.
All right. Take care, everybody. Bye.